Thank you for joining us today. My name is Sharissa Martin. I am the program manager for the American Society for Cell Biology. We welcome you to join us for another webinar within our webinar series, this one focusing on immigration for scientific research. Today, we have Brian Getson joining us. Brian Getson is a graduate of the University of Pennsylvania Law School with more than 25 years of experience. He is a leading U.S. immigration lawyer who represents scientific researchers in applying for green cards and in the principal of a boutique immigration law firm based in Philadelphia, Pennsylvania. Mr. Getson has given presentations on green cards for scientific researchers at numerous major scientific conferences, the Whitzer Institute, and at universities. Mr. Getson often provides a money-back guarantee to qualified applicants, giving clients confidence that they will get the results. Before Brian joins us, I just want to remind you that any questions that you have for our speaker should be entered into the Q&A feature at the bottom of your screen. Mr. Getson, please take it over.
Very good. Thank you so much for having me today, Sharissa. I'm very happy to be here. So to give you a little bit of background about myself, I'm a graduate of the University of Pennsylvania Law School. I've been practicing immigration law for more than 25 years. I specialize in green cards for scientific researchers, and I've authored a book called Obtaining a U.S. Visa Based on Achievement. So the Trump administration seems like a long time ago. So everything that everybody was worried about, not giving visas out, not approving green cards, taking away OPT-EAD, all of those things are over. And we've been in a new era in the Biden administration. So the Immigration Service is, operating normally. We're past COVID and they are approving cases and, things are getting as close to pre-COVID as possible. And so if you're looking to live and work in the United States and stay here with a green card, then now is a good time to be thinking about applying. So the webinar today, it's in two parts. The first part is on maintaining your non-immigrant status, making sure that you have the right to live and work in the United States at all times, and then thinking about when to file for the green card within the context of your non-immigrant status. And then the second part is on your credentials to be awarded the green card. So if you're here in the United States, you're either a student in F1 status or you're working. And if you're working, you're either in postdoc or you're in industry. So the ways to maintain your status are different if you're in a postdoc than if you are in industry. And I always say to take whatever job you want that is going to make you happy, that's going to best further your career, and then let the immigration follow. If you want to be in academia, be in academia. If you want to be in industry, be in industry, and then figure out the immigration. Because you have to, be happy with what you're doing, and the immigration may not work out no matter what you do. So take the job you want and let the immigration follow. So if you're in a postdoc, then you have more options than in terms of maintaining your non-immigrant status. So if you're in F1 and you graduate, you have 3 years of OPT EAD, and you can, work anywhere you want related to your degree program. If you're in a postdoc, you are eligible for H-1B status without having to go through the lottery. You're also eligible for J-1 status. And, perhaps you're able to apply for a green card and be able to maintain your status that way in a postdoc. If you're in industry, you have the same 3 years of OPT EAD where you can work in any job related to your degree. But then for H-1B, there's a lottery, and it's a random lottery, and you have to be selected in the lottery, and then you would have to apply for the H-1B petition and have it be approved. And the lottery is as tough as it's ever been in terms of the numbers. And then In industry, you could also be eligible for O1 status, and that is an extraordinary ability visa. It's the non-immigrant equivalent of EB-1A. And likewise, you might be able to apply for a green card in order to maintain your status. So talking about each of those different types, again, if you're in F1, when you graduate, you have 3 years of OPT. So can you apply for a green card during OPT? The answer is yes. You can apply for a green card at any time, but you have to, number one, make sure you're qualified. And number two, you have to manage visa backlogs now. So, for nearly everybody now is subject to some type of visa backlog. And what a visa backlog means is that there's 2 steps to applying for a green card. There's an I-140 petition, and that's the petition based on your research credentials. And then there's an I-485 green card application. So you can file an I-140 petition at any time, but you can't file an I-485 green card application until the date of your I-140 is not backlogged. And I'm going to talk about that a little bit later. But it used to be, before the backlogs, that you could possibly, during your OPT, if you were not from China and India, when there was no backlog in the NIW category, you could file for a green card and perhaps get an EAD or even the green card by the time your OPT expired, but that's not so easy anymore. So you need to consider the expiration dates of your OPT and your credentials and the backlogs when deciding, if a green card is able to let you maintain your status at the end of the OPT. H-1B, so again, if you're in a postdoc situation, there's no lottery, you're cap exempt, you can be sponsored at any time for H-1B. If you are in industry, then you have to go through a visa lottery. The visa lottery runs March of every year, and you have to register basic information into an online database, and then USCIS runs the lottery. So we don't have the lottery numbers officially yet from last month, but just in terms of what I saw in my practice and talking with colleagues, we are almost certain that it was less than 20% of the entrants won the lottery. There are 65,000 regular lottery visas and 20,000 for U.S. master's degrees and higher. And, we're thinking that there could have been close to 600,000 applications for the 85,000 slots. So, if you don't win the lottery, then you have to have a plan if you're in industry. So if you never win the lottery, the only way you can keep working in industry is if you either are able to get a green card, if that's feasible, or the company would have to sponsor you for O1A status. Otherwise, you'd have to continue your education or you'd have to go back to a postdoc. So, you need to be planning ahead and understand what the roadmap is, and you should be having communication with your employer, right? If you're going to an industry job, make sure they're going to sponsor you in the H-1B lottery. If you're going to a university postdoc, ask if they're willing to sponsor you for H-1B as opposed to J-1. So, and just always have be thinking ahead in terms of what you're going to do, because, a lottery is extremely random. So H-1B is better than J-1 if you're in a postdoc setting for numerous reasons. Number one is that H-1B is dual intent. And what that means is that if you file an I-140 petition, you can still travel outside of the United States. And if you file an I-485 green card application, you could still extend your H-1B, and that's not the case with the J-1. Also, H-1B has a 6-year limit. J-1 has a 5-year limit. If you're in a green card petition situation and you're in a backlog, then you could extend your H-1B beyond 6 years. You don't want a J-1 unless you have no choice because of the dual intent. Also, there's something called a 2-year home residency requirement, where If you're in J1 status, then you might be subject to this 2-year rule. And what that means is you can't change to H-1B or get a green card unless you go back to your home country for 2 years or obtain a waiver. Most waivers are very straightforward and simple to obtain. It's called a no objection waiver that you obtain through your home country. So, if you have no choice but to go on a J1, and most university postdoc positions use the J1 because the university can pay you less than the H-1B, then you take the J1. But again, if you're able to talk with your PI, talk with the university, and go to H-1B, that's better. So when would you use the O1? So the O1 is typically only used in industry. The only real time it's used in academia is if you are subject to a 2-year home residency requirement and you can't waive it. Like if you had a Fulbright scholarship, those are extremely difficult, bordering on impossible to waive. So sometimes people who can't waive the 2-year requirement use O1 for university. But most of the time an O1 is used in industry. So number one, if you don't win the H-1B lottery, then you need to use the O1. Number two, as I indicated, if you're subject to the 2-year rule, you can still hold an O1. You couldn't change your status from within the US, but if the O1 was approved, you could leave the US, apply for a visa at an embassy, and return. If you didn't apply for a green card early enough and you can't extend H-1B beyond 6 years, then you can apply for O1. And the most common use of the O1 is postdocs that want to transition to industry. So if you want to transition to industry, you don't have to go through the lottery. A company's not going to want to wait that long to hire you. So you would try the O1 in order to transition to industry. And, the only other real way to work for industry in a postdoc situation is if you're in a cap-exempt H-1B status, and you're working part-time or full-time for a university, then you can have a second H-1B petition for an industry company approved by USCIS for a part-time job. And that petition doesn't need to go through the lottery. So in other words, you have 2 approved H-1B jobs and you're working for 2 employers, one for the university, one for the industry, and the industry doesn't go through the H-1B lottery. But again, the most common use of the O1 is to go work in industry from academia. So what are the paths to a green card? So the normal way that foreign nationals apply for a green card is through a perm labor certification. And that requires an employer sponsor and showing a lack of U.S. worker availability. The employer has to advertise for U.S. workers and show that they can't find anybody qualified. All of you listening, you want to try and avoid that labor certification. You want to try and apply for a green card based on your own research accomplishments. And there's 3 categories to do that. There's the EB1 categories, and that is EB1A, extraordinary ability, where you can self-file. There's EB1B, outstanding researchers, professors. That requires an employer sponsor. And then there's EB2, national interest waiver, which you can also file on your own. So there's a lot of strategy that goes into filing for a green card. So you need to have a roadmap, a plan. Again, you need to understand what's your current non-immigrant status, how are you going to maintain it? You need to be communicating with your employer. And then you need to have a backup plan in case, your primary plan does not work out. So what are the factors that sort of we take into consideration about green card filing strategy and timing? So number one is, when does your current status expire, and can you extend your status or change your status? So in other words, if you're in J1, can you change to H-1B? If you're in H-1B, how much time do you have left in your 6 years? So that goes into the decision making. Are you in industry? Are you in a postdoc? If you're in a postdoc, you're going to be continuing to publish and present and build your credentials. Whereas if you're in industry and you're not publicly disseminating your work anymore, if it's all proprietary, then maybe that would speed up the timing of filing for the green card. Most importantly is, how strong is your case and will it improve in the near future? what matters more than anything is getting the case approved. So, your credentials are extremely relevant to the decision of when to file for a green card. So, if you have a certain number of citations and you think that the citation level, you're seeing it grow quickly within the next 6 to 12 months, maybe you wait 6 to 12 months. If, things aren't changing much, then maybe that would lead to filing a little bit earlier. Sometimes there's family and job considerations, and, maybe spouses are living apart, or you need a green card to get funding or to have a clearance or whatever it may be. And, also, what country are you born in, right? That matters a lot too. And what category are you filing? So let's talk about that, how to get a green card while avoiding the perm labor certification. So each month, the Department of State publishes what's called a visa bulletin. And you should be checking the visa bulletin. And what the visa bulletin tells you is that there's a limit on the number of green cards that are issued by the US government each year. And so in the different categories, the EB1 and the EB2 NIW, there is a certain number of green cards that are issued. And no one country can have any more than 28% of the total green cards. So right now we're sitting in, for where we are in May of 2023, the demand for green cards is exceeding the supply for green cards in nearly every category for every country. So the State Department Visa Bulletin tells you when you can file the I-485 green card application. Remember, there's 2 steps to get a green card: the I-140 petition, which is EB1A, EB1B, NIW, and then the I-485 green card application. And the Visa Bulletin has 2 different charts. One chart is called the date for filing chart, and that means the date you can file the 485. And the other chart is called the final action date chart, and that means the date they'll give you the green card. Right now, immigration is not using the date for filing chart. They're using the final action date chart for both. They're trying to keep the numbers down. The fiscal year for the government restarts on October 1st. So typically on October 1st, they go back to using the date for filing chart, and that's when, we see some movement in the numbers. So if you are, I'm going to go from right to left now. If you're born in any country other than China or India, there is a wait to file the green card in the national interest waiver category. I have been practicing law for 27 years, and this is the first time in my career that there has been a prolonged wait in the NIW category. So this is new to all of us. And there's nobody who knows what these dates are going to look like going forward. And the EB1 dates are current for the world. So, we're all hoping that the NIW dates do progress as the year goes on, especially come October, but we don't know for sure. So if you're from the world, if you can try and get an EB1, if you're potentially qualified, then certainly that would be great because you wouldn't have to wait for the green card. But the green card wait, again, there was no wait ever, but now there is. So, if you just want to file the NIW to get into the line, if that's what you're qualified for. If you're from India, right, you're looking at a wait in the EB1 category of more than a year. But you go down to the EB2 NIW category and you're looking at a more than 12-year wait. So understandably, every single person that I talk to from India wants to file for EB1A or EB1B. It's human nature, okay? So because everybody wants to file, which again, I get, it's the highest level of EB1A filings ever, and it's also the greatest number of denials that I've ever seen. So the legal standard for EB1A has grown significantly, and it's very difficult to get an EB1A petition approved right now. So, if you're from India, you have to think about strategy, right? It might not make sense to file an EB1A if you're not qualified, even though that's what you want. You might want to start with an NIW, establish a priority date, get that approved, and then file an EB1A. China, you're in the middle, right? You have the same backlog for the EB1 as India, but the backlog for NIW is, approximately 4 years, and, it's not the same. Sorry, 5 years. So, if you're from China, you have the middle ground. If you're from India, you have the really long wait in NIW, and the world, you're having this shorter wait. So the strategy, in addition to all the other things that I talked about, in terms of your credentials, your status, the visa bulletin also factors into that. So sometimes it makes sense to file an NIW first and an EB1 later. So understand that if you're from China or India, you can't apply for the green card anyway, even if you have an approved EB1 petition. There's still a wait of more than a year. So, as an example, if you're on OPT and you have 175 sites and no significant factors, you're probably not going to win an EB1 case. And if USCIS denies you once, they're likely to deny you twice. So you have to be really cautious about an EB1 filing. So a strategy that makes sense for many people is you file the national interest waiver petition first, and you establish a priority date. What that means is the date you file the I-140 petition is called the priority date. That's the filing date. And that's the date in that visa bulletin that we're looking at. Whatever date you file the I-140 petition has to be before the date in the visa bulletin to file the 485. So let's say that I filed an NIW petition today on April 25th, 2023. So now I am locked into that date, April 25th, 2023. And let's say my NIW petition is approved. So now I watch the visa bulletin. When the April 25th, 2023 date is near current in the EB1 category, then I file my EB1. And it's as if I'm filing my EB1 on April 25th, 2023. So even if I were filing the EB1 on November 25th, 2024, I get to retain the April 25th, 2023 priority date. So now I am not getting my green card any faster or slower by having waited to file the EB1, because I get to use the priority date of the NIW. But I've waited more than a year and a half, and now my credentials are a lot stronger, so I have a much better chance for EB1 approval. So also, the Immigration Service knows that I have an approved national interest waiver petition, so they might look at my EB1 differently. It's like they know I'm going to get the green card. So are they going to be nice and not make me wait this extra time, or are they going to be mean and deny my EB1 knowing that I have an NIW? So you have to think about that if you're from China or India, and even from the world now. If you're qualified for an NIW, you file the NIW, and then maybe if the dates don't move, you would file an EB1 in the future. If you have a strong EB1 case, you don't need to wait to file it, but you should still file an NIW as insurance. So in other words, if we feel that your case has a reasonable chance for EB1 approval, then I would want you not waiting. I'd want you filing that right now, because if you wait, you have to do more work. You have to update the whole case in a year and a half or whenever you're going to file it. So if your EB1 case is strong, go ahead and file the EB1 case immediately. But you should still file a national interest waiver as insurance in case your EB1 is denied. So, and that's a mistake I see a lot of people make is, if your EB1 is not approved, then you're going to have to wind up filing the NIW anyway, but you would have lost all of the time to get into the waiting line by waiting for the EB1 to get denied. So it's similar to car insurance, right? If you get into the car accident, you're glad you have the insurance. If you EB1 is denied, you're glad you have the insurance of the NIW. And the work is exactly the same. It's just, if when I prepare EB1 and NIW at the same time, I don't charge anymore. All I'm doing is another set of forms and I'm reworking the cover letter, and we're having the same set of letters in both cases. So you can't premium process the 485. And it also doesn't make sense to premium process an I-140 if you're in a backlog. So, everybody is like, oh, I can premium process, I'm going to get my green card faster. Well, you're not, because even if you have an approved NIW or EB1, then you still have to wait for the priority date to become current. So there really is, it doesn't make a lot of sense to premium process right now. The only time it does make sense is if you need an approved I-140 petition for a spouse to get an H-4 EAD, then it would make sense to premium process. Otherwise, it doesn't, unless you already have a priority date from an NIW that would make an EB1 current, and then maybe you would premium process. So, it's just sort of understanding this whole strategy of managing the backlogs in the visa bulletin. And this is all on an individual case-by-case basis, right? Like, your case is not your friend's case. Whatever happened to your friend, their credentials are not your credentials. And so each case is unique and different, and you have to analyze it based on you. So now, how do you win in EB1 NIW case? So the first method is you've won the Nobel Prize. And I say, good luck with this method. I have never had a client who won the Nobel Prize, and you certainly don't need to win the Nobel Prize to get a green card. So method number two is that in EB1A, there's 3 categories, and there are 10 categories and you need to meet 3. In EB1B, there are 6 categories and you need to meet 2. And in NIW, all of the evidence counts. There's no set categories. You make your case however you would like, but you tend to follow along the EB1 categories. So, as I've said, EB1A is the most difficult it's ever been. Immigration is, so as I said, it's the most applications ever. So what's the easiest way for immigration to distinguish between applicants? Its level of citation, right? Everybody's a good researcher. Everybody's smart. Everybody's doing good things to benefit humanity. So when you're getting so many filings in sheer volume, the easiest way for the Immigration Service to distinguish among applicants is citation level. And that's not always fair because some people have more highly cited fields than others, but that's what they do. And the standard for EB1A approval has gotten really, really difficult. We are seeing the vast majority of cases be denied with less than 1,000 citations. So, if you have less than 300, you shouldn't even be thinking about EB1A. But, in between 300 and 1,000, I know everybody wants to file, but the reality is that immigration is denying most cases under 1,000 citations, which is, vastly different than what was happening in the past. What I have been seeing is that, everyone with EB1A, everybody meets the same 3 basic categories, which is publications, peer review, and original scientific contributions of major significance. So if you're able to somehow have a 4th category, that's going to help your chances for EB1A. With EB1B, it's easier than EB1A, right? You don't need nearly as many citations, but you have to have an employer sponsor and you have to have a qualifying position. So if you're from China or India or even the world and you can be sponsored for EB1B, that's the way to go over EB1A. And then again, with NIW, I feel comfortable giving a money back guarantee with 75 to 100 citations or higher, but NIW cases get approved with less than that. So when we look at the specific categories, you have receipt of national or international recognized awards in the field. So this is extremely hard for EB1A. You have to have an award that is on a national or international level and that is open to anybody at any career stage, not just young people, early career researchers, things like that. It's different for O1A. The O1A standards are easier than EB1A. With O1A, you can use an award like a national PhD fellowship or an award that you receive from a conference, et cetera. So, many times people get approved for O1A and denied for EB1A, and the reason is that the legal standard is different. The awards are not so important for EB1B or NIW. Membership in associations that require achievement. So this is, again, very difficult. It's usually fellowship level memberships, like the IEEE fellowship is an example. The Royal Society of London, the National Academy of Sciences, those are the extreme examples of achievement-based memberships. But, just being a member of ASCB where you can pay dues and join, that's not going to count for green card purposes. Next, publish material about you and your work in journals or major media public platforms. This is other people writing about you, a press release about your work, a journal comment, editorial, etc. This is, again, where there's a distinction between EB1A and O1A. With O1A, if the article is about your paper, it's good enough. With EB1A, your name has to be in the article itself. The article has to be about you. So this is something that you can control, potentially. You can reach out to the press office, the media office of your university and ask if they're willing to do a press release and include your name and your PI's name. If you're working in industry, maybe the company can do a press release. So I always say it's free to ask. Right? If you ask for a press release, maybe they'll say yes and do it. Maybe they'll say no, but if you don't ask, you won't know. So now, again, the three most common categories that I talked about is judging the work of others. So this means doing peer review for journals in your own name, not for your PI. This is helpful in every category, every EB1A, EB1B, NIW. The journal has to, again, ask you directly. So be your own advocate here. Reach out to the journals where you have published. Ask them to do peer review. Call them. Talk to them when you go to conferences. Ask your PI for help. Volume is better, right? 10 is better than 5. 15 is better than 10. And the impact factor of the journal doesn't really matter. It's just the more peer review you do, the better. So now, everybody tries to show original contributions of significance. And the way you do that is through objective evidence, including citation level, and through reference letters. So what's the evidence that we give immigration when we prepare a case? We give the Google Scholar citation page, and we give the first page of the publication. Publications count even if you are not the first author. So you want to give all of your publications, and when you're writing the letters, you can consider your research as your own if your name is on the publication. And there's case law that says that. So you never want to say you work as a team or you collaborated or whatever. You can say you discovered if your name is on the publication. We give the abstracts of your conference presentations. We give sample articles that have cited your work with the citation of your work highlighted. If there's any news media articles about your work, we give that. If anybody has randomly reached out to you by email or LinkedIn or ResearchGate to ask for your advice or expertise or a full text paper, I like to give that. We're trying to establish you're an expert in the field. So if others are reaching out to you for your expertise, that is good objective evidence to immigration that others consider you an expert. Then if you have any patents or funding, we give evidence of that, and funding is important, especially if it's commercialized. So the letters are the most important part of your case. Writing the letters is a reason you should hire an attorney and not do this by yourself. And because, letters are really can be make or break. If you don't do the letters properly, then immigration can use your own letters against you to deny your case. So when we prepare a case, we normally give 3 different kinds of letters. The first kind is called an independent letter. And independent means the author has never worked or gone to school where you have worked or gone to school. They're not a co-author, they're not a collaborator. Maybe they met you at a conference or they cited you or it's your PI's friend. And I like to have 3 letters from people in the US and 2 from outside or the other way around. And these independent letters provide an overview of your career that is publicly available. So I like to have the independent letters talk about all of your accomplishments rather than have one letter talk about project 1, a second letter talk about project 2, and so on. And the concept of independent means that, they're not as affiliated with you, right? We know that other people in your lab would say nice things about you. An alumni of your university would have a vested interest in helping out a fellow alumni. So immigration wants to hear from independent people. The second set of letters is from your supervisors. Your supervisors would talk about the work done under their supervision. Then the third set of letters is what I call supplemental letters. And those are short letters. They're no more than 2 pages long, and they're trying to show the impact of your work on the field. And, not all law firms write these supplemental letters, but they really make a big difference in a case. If there's a private company who is interested in or using your research, have the company write a letter about that. If there's a government agency, likewise, the Army, the Department of Energy, the FDA, the USDA, whatever it may be, a 1 to 2 page letter from a government agency is fantastic. People who have cited you, how did they use your work to help their own? If you engaged in a collaboration with another university outside of where you worked, talk about how you benefited the collaboration. If you were selected or invited to give an oral conference presentation, well, that's different than a poster. So that's important to show why you were selected to do that. And if you have any commercialization or funding in your name, get a letter about that. So our law firm, we would write the letters for you. You would outline your research based on samples that I would give you. We would then ask questions to make your research more simple and understandable, and then we would write the letters for you. As I would send you each letter, you would edit it using Microsoft Word track changes, and then you would, once it gets finalized, you would send it to the author to print on letterhead and sign. And then we use a secure file sharing service called Basecamp, where you would upload the letters and evidence. So why are our letters effective? It's, we have the independent letters discuss everything. We write these supplemental letters. And most importantly, we avoid problematic language. So, the Immigration Service, I've seen many requests for evidence, many decisions. I know what they're looking for. I know what not to put in letters. So the number one, because sometimes I will read a decision where immigration denies the person's case because of the letters that they submitted. In other words, they use their own letters and turn it against them to deny the case. So what is problematic language? So the most basic problematic language is speculative language. Words like potential, may, might, future, could, promising. Immigration is only giving you a green card based on your existing research accomplishments. Something that has the potential to cure cancer has the potential to not cure cancer. So never, ever include speculative language in letters. They're not interested in what may happen in the future because it may not. Number two, never call yourself an early career young researcher. You are being compared to all researchers at all career stages. You are not showing you are among the small percentage of early career researchers at the top of the field in the world. You are among the small percentage of all researchers at the top of the field in the world. Then again, I said, don't talk about working as a team and collaboration, et cetera. Immigration knows there's co-authors on your publications. Everyone works collaboratively with research. So you don't need to do that. And then I don't like to give metrics of your authors, right? You might think, oh, I have a Nobel Prize winner writing my letter, and that's fine. But if the Nobel Prize winner says they have 800 publications and 25,000 citations, well, that makes your credentials look really weak, right? So, it's fine to have anybody, in your field write a letter, but just don't put metrics right in front of the Immigration Service. They'll say your author's at the top of the field and not you. And then we use experienced science writers. We have a whole team of people, and all they do is write these letters. They all have, science-related education, and they're really good at understanding how to write letters. And I review every single letter that leaves our office. Next category, authorship of journal articles. So again, this is the first page of your publications. It doesn't really matter the impact factor of the journal. What matters more is just volume. The more publications you have, the higher level of citation that counts more. Display of work at artistic exhibitions. This is not applicable to researchers. Playing a leading or critical role for an organization with a distinguished reputation. This is really relevant to O1A and EB1A. And the law has recently changed where you don't have to show that you play a leading or critical role for the whole organization, just your department or division. So that becomes easier. And again, when we're looking to try and expand categories, this is a good one to try and see if you qualify. Leading role typically has to do with seniority, with job title, and critical role means you're doing something positive for the organization. You've received funding, your work is in a clinical trial, you're mentoring others, you have patents that are commercialized, things like that. High salary compared to others in the field. Typically this is not applicable to researchers, but if you're in a company, we would look into it. And then commercial success in a box office. So the EB1A legal standard, again, you're the small percentage at the very top of the field in the world. You've received sustained national or international acclaim. And then there's something called Kazarian, where even if you meet 3 of the categories, you can still be denied. You have to show by what's called the totality of the circumstances that you meet the high level. EB1B, international recognition as outstanding, meaning 2 categories. You have to have a tenure or tenure track teaching or a permanent research position, and that can be in academic or industry. Permanent research position means beyond a postdoc. You have to have at least 3 years of research experience. That has to be beyond the PhD level, unless you can show your PhD research is outstanding. But usually you're not going to have that permanent research position until at least 3 years past PhD. And then we have the same Kazarian standard. So again, if you can get an EB1B sponsor, you have a much higher chance for EB1 approval than EB1A. The thing with EB1B, though, it's employer-based, so it belongs to the employer, not you, and you have to stay in the job for at least 180 days after filing the 485, and then you could change to a same or similar position and keep your green card. So that's why people like EB1A over EB1B. You're not tied to the employer, because when you're looking at a backlog of more than a year, but that who knows what that's going to actually be, plus 180 days, you could be stuck with your employer for a while until you can leave. National interest waiver, you have to have an advanced degree, which all of you do. You have to demonstrate that your employment's in the national interest. And the case that governs that is called the matter of Danisar. And there's 3 things that you have to show. Number 1, your proposed endeavor is of substantial merit and national importance. For you, that's benefiting healthcare, the environment, the economy. Everyone's research, we can show that. Number 2, you're well positioned to advance the proposed endeavor. that's basically based on your job and your accomplishments. So, I don't like filing NIWs before you graduate your PhD program. You're going to have 3 years of OPT EAD after you graduate. You can work wherever you want. I'm much more comfortable filing an NIW when you can say, hey, I have a job. If you give me a green card, I'm going to keep working in this job, or I'll work in the same field. And then the third is, on balance, we don't care about U.S. workers, right? You have accomplished such a significant degree in your field in terms of your research accomplishments, your scientific accomplishments, that we're not going to care about U.S. workers. So that's what's involved with the NIW. Again, I talked about premium processing a little bit earlier. You can expedite for $2,500 any case. You have a 15-day decision for EB1 and 45 days for NIW. You're more likely to receive an RFE or denial with premium processing. With the backlogs, it doesn't make any sense to premium process. To reiterate, the only time to really do this is your spouse needs an H4 EAD, or you already have an approved NIW and you're going for an EB1 now. Defining your field of research is extremely important in these cases. So you have to say you're a scientist in the field of blank, and then you fill in the blank. And your field, it can't be so broad, right? Like, it can't be cell biology. It's hard to show you've impacted the field of cell biology. But it has to be broad enough to cover all of your work, right? Sometimes your PhD is in one area, your postdoc is in another. Sometimes you might want to go to industry and you might not necessarily be researching still. You might be consulting, you might be advising, you might be being a medical writer. So you don't want to use the word research in your field. So, because you have to continue to work in the same field prior to receiving the green card, and then for maybe 6 to 9 months thereafter. So the field definition is extremely important. Like, if you're working on understanding the molecular mechanisms of protein-protein interactions, and all of your publications are about that, and you're gonna, keep researching that, that's a good field definition, right? So that's something where, me as the lawyer, I help you define your field, factoring in all of these. So again, why choose our law firm? Well, we offer a money-back guarantee for most clients, and I normally base that on site level, but we are one of very few law firms in the country that will refund your money if your case is not approved. Again, we have a team of science writers, and I've been doing this a long time, and I've filed a lot of cases. I have a really good understanding about how to prepare a case and what the Immigration Service is looking for. So we give free consultations year-round. You can visit our website at researchyourgreencard.com. You can email me, you can fill out the contact form, or there's an online scheduler where you can just go ahead and schedule a one-on-one consultation with me by Zoom or Skype or telephone. And you just go in, and my calendar's in there, and you just schedule. And again, it's always a really good idea to have an individual consultation, because your case is unique to you. So that's everything. We have time for questions. Please ask whatever questions you have in the Q&A, and Sharisa will read them.
Thank you so much, Brian. That was a lot of good information. And we have a few questions came in, not too many. We have about 12 minutes to kind of work through them. So the first question that we have, USCIS websites are stating maximum processing times for H-1B non-lottery visas are 3 months. Are these accurate?
Yes, I think for H-1Bs, they're pretty accurate. We're seeing most cases with non-premium processed in the 3-month time frame, maybe to 4 months. But, I just had an approval yesterday that was within that 3-month time.
All right, next up. What happens if your STEM EAD expires and H-1B is still in processing?
So you're allowed to remain lawfully in the United States while the H-1B petition is processing. You just can't work after your STEM EAD expires, before the H-1B is approved, but you really shouldn't be in that situation, because that's where you would recommend using premium processing to make sure that your H-1B is approved before the STEM expires. And that way there's no lapse in work authorization. But the answer to that direct question is you could stay in the US, you'd have to stop working until the H-1B is approved.
Awesome. And I see a couple questions coming in the chat. Just a reminder, please use the Q&A feature at the bottom of your screen to insert any questions that you may have for our speaker today. All right, the next one says, I am still doing my PhD and will be graduating next year. Will applying for the NIW right away affect my OPT application next year?
So the answer is no. An I-140 petition does not affect your ability to get an OPT. It does not affect your ability to get a STEM OPT EAD extension. What it does affect is your ability to travel. You certainly would not be issued a new F1 visa at a US embassy if you've applied for an I-140, and I strongly discourage travel with an existing F1 visa after you filed an I-140, because you don't know what would happen at the airport. But again, as I said earlier, I am inclined to advise you to wait until you actually have your PhD degree before filing the I-140. It's fine to prepare beforehand, but again, I like you to have that job before you file the I-140. It's not necessary. Cases can be approved before you graduate the PhD, but remember, if it's denied once, it's nearly impossible to get it approved the second time around. So you want to just be smart about the timing.
Okay. And the next one, they have two questions kind of in one. Would you recommend going through the green card application process during a PhD F1, or is it better to apply after completion of the PhD to increase my chances of petition approval?
Yeah, so that's what I just talked about. I'd rather you apply after you graduate to increase the petition approval. You're going to have 3 years of OPT. You can hopefully be able to maintain your non-immigrant status. I understand, the benefits of the green card, but just applying before a PhD is not as strong of a case after a PhD. And it's really not going to change your life much, right? You're still going to be going to school. You're still going to be able to work with the OPT EAD for 3 years. So it's always better, in my opinion, to wait until you graduate.
Okay. Do you take cases with J1 2-year resident requirement?
Absolutely, yes. So again, the green card process, we have two parts, the I-140, the 485. You can file the I-140 at any time. You can file the I-140 while you're in J1, while you're subject to the 2-year requirement. None of it matters. You just can't travel after you file the I-140, and you can't file for the green card until you get the waiver. But because of the backlogs now, it probably makes sense to file the I-140 while you are subject to the 2-year requirement to get into the line. Remember, the sooner you file, the sooner you get into the line, the sooner you get the green card. You just have to manage traveling. And again, the traveling is not restricted if you're in H-1B, and you'd have to manage the waiver.
Okay, and then I have two questions regarding EB-1A. I have 3 years left on my H-1B in academia. When would be the ideal time to apply for an EB-1A?
So it depends on your citation level and what country you're born in. That's really what I would be looking for. I would say, okay, I just said that the Immigration Service is denying the vast majority of cases below 1,000 citations. So what makes sense for you? Does it make sense to file a national interest waiver petition to get into the line? If the NIW is approved, you'll be able to stay in H-1B status beyond 6 years. And then you'll be able to use that same priority date and substitute it into a future EB-1A. So what's your citation level? Can you try and meet more than 3 categories? That is a case-specific answer as opposed to a general answer.
Okay. Do grants received count in the application for the EB-1A or B?
So do they count? Yes. Are they a different category? No. So, the Immigration Service is not going to consider a grant as an award for the most part for EB-1A, EB-1B. But if you had a grant in your own name, would I include that as part of the original scientific contributions of major significance? Definitely yes. Would I try and get a letter about that? Definitely yes. So it is a very positive factor if you have a funding or grant in your own name. Maybe it could count in the award category depending on the nature of the grant, but you would just have to look at how to use that. But yes, it would be helpful.
Does nationality affect NIW?
So the answer is that immigration is not approving or denying a case based on nationality. It's completely blind to that. They're only looking at your research accomplishments. But the nationality dictates where you are in that waiting line. So remember, you have India is the longest wait for NIW, China is in the middle, and the world has, the shortest wait right now. So, the nationality is going to dictate the strategy in terms of NIW, EB1A, et cetera. But a case is not approved or denied at all based on nationality.
Okay, and then we have two more in case anyone wants to put any more questions in the Q&A at the bottom of their screen. What number of citations and peer reviews are recommended for the NIW for an Indian national?
Sure. So for NIW, again, it doesn't matter what nationality you are. You don't need any peer reviews for an NIW, but it's good to have. It's helpful to have. If you're listening, just do peer review, right? Start trying to get that done. But you can file NIW without peer review. So the number of peer review doesn't matter. Any type of peer review is helpful for an NIW. For an EB1A, you'd like to see 10 to 15 peer review or higher, and, just more is better. Same thing with an EB1B about that number. In terms of citations, again, for NIW, I'm comfortable with a money-back guarantee at 75 to 100 citations. If you're below 75, then let's talk, right? Where is your citation level trending? If you're at 40 and you're not going to get to 75 for 3 years, it probably doesn't make sense to wait. If you're at 40 and you're going to be at 75 in 3 months, it probably makes sense to wait. So, it's the citation is much more lax with NIWs. NIWs can be approved at any level of citation, but NIWs can also be denied, right? They don't approve 100% of NIWs. So you have to just be smart and strategic about where's your citation level, where are you in your overall non-immigrant status, where is it trending, et cetera. And again, that's why the one-on-one consultation is really good. There's no reason to not have a free consultation and to, find out what's best for your particular situation.
All right. And so that explanation actually answered the last question that was in the chat. So I don't see any other ones coming in. So I want to go ahead and thank you, Brian, for taking the time to speak with us today and give this amazing presentation. As stated before, you can contact Brian for a consultation or to sit down and have a conversation that address some of your more specific conversations or questions. This presentation will be recorded and it will be posted on our ASCB website. In addition, please mark your calendars for our upcoming webinar, which is going to be focusing on general principles and visualization tools for active learning in biology. This will be taking place on May 24th at noon Eastern Standard Time. Thank you all for joining us and have a wonderful day.